Yes, Dr. Thomas E. Woods, Jr. is a senior fellow at the Ludwig von Mises Institute. Dr. Woods will be joining us in just one moment to tell us about nullification, the 10th Amendment of the Constitution, and also comment, if we have time, on the economic meltdown. His website is www.tomwoods.com. Dr. Woods holds a bachelor's degree in history from Harvard and his master's and PhD from Columbia University. He is the author of 10 books, most recently Nullification, How to Resist Federal Tyranny in the 21st Century. His other books include New York Times bestsellers Meltdown, The Politically Incorrect Guide to American History, as well as Who Killed the Constitution, The Fate of American Liberty from World War I to George W. Bush, Sacred Then and Now, 33 Questions About American History You're Not Supposed to Ask, as well as the Church and the Market. And I believe he's also coming up with a book shortly called Rollback. But without further ado, Dr. Woods, are you with us?
I certainly am, Jake, and everyone. Thanks for having me.
And thanks so much for joining us here today. I was wondering for our audience if we could just start off, if you could tell us a bit about the whole idea of what nullification, or as you write in the book, the idea of interposition is, and also how can we use it to, as you say, resist federal tyranny in the 21st century?
Well, this is an idea that, as you might imagine, the mainstream media has more or less demonized. So, it's nice to speak to an audience that doesn't just, drone-like, listen to what Fox News or MSNBC tells them. That's encouraging. But basically, we're talking about Thomas Jefferson, so of course, it's not going to be liked. But basically, it boils down to this. Jefferson was worried about, what do you do in a situation in which you have a federal government that just more or less acts without any restraint on it? And I think that's more or less what we're enduring now. We have a presidency, regardless of which party occupies it, that they think that they can spy on us, they can start wars, they can misuse the National Guard, they can engage in all manner of civil liberties violations, and it doesn't matter if there's an R or a D next to the name, it just keeps happening and it keeps getting worse, and on and on. We think of the civil liberty catastrophes associated with the war on drugs, and we got millions of people languishing in government cages who haven't committed any violent act. At some point, it's not enough any longer just to give speeches about what a terrible situation this is. At some point, you have to say, is there anything we can actually do about it, short of, waiting till the year 2800 when, something actually might get done. So Jefferson's question was, what do we do? Is there anything we can do with a federal government that acts like this? And his answer was, sure, you could vote the people out, but what about a situation like ours, when no matter which candidate you vote for, you still get the stinking drug war. No matter which candidate you vote for, you still get the lousy wars. No matter which candidate you vote for, you still get the bailouts. No matter which candidate you vote for, the bankers and the corporations are still running the show. At some point, you have to stop being a sucker. And so Jefferson said that ultimately, in the last resort, there has to be some local power, and his view at the state level, that can say to the federal government, look, you have gone too far. This is clearly a power not given to you in the Constitution, and so we simply at our state level will refuse to enforce this. And this is an idea that was used by some of the most courageous people of the 19th century, who referred to Jefferson's idea as late as 1859 to refuse to enforce the Fugitive Slave Act of 1850. So it's something that, ought not to just be demonized and dismissed, but seriously considered by people who genuinely believe that small is beautiful and that large, anonymous, bureaucratic structures are not the most humane way for people to interact with each other.
Right, and as you say, the whole idea of Thomas Jefferson had some, for a while, and you could argue about this, the Democrat Party in the United States was also the party of states' rights and also championing laissez-faire. No longer is the case, but used to be that way. I wanted to talk a little bit about the Supreme Court, and, when most Americans hear about the Supreme Court, they think that that's, the final place where all things can be decided, which, of course, is a branch of the federal government along with the executive and legislative branches. in this idea of having nullification, where should the final court of appeals be for something, whether it's medicinal marijuana or the National Guard or whatever, where you have a case where the federal government disagrees with the states, in your opinion?
Right. Well, it's important to remember that Lincoln himself was of the opinion that the Supreme Court's decision in Dred Scott versus Sanford of 1857 should not be enforced, because that was just an abuse. That obiter dicta in that case was an abuse and was not constitutional, so should not be enforced. So it's not some crazy doctrine to hold that 9 people sitting there in black robes, may not be infallible. Well, I think it would be rank superstition to think that they are infallible. Well, basically what we see from, for instance, James Madison, who wrote about this in his famous Virginia Report of 1800, Madison took sort of a more middle-of-the-road view than Jefferson did. Madison's view was that the Supreme Court should, in fact, be the final arbiter among the 3 branches of government. But among the executive, legislative, and judicial. The judicial branch has the final say, but he says it can't have the final say with regard to the system as a whole. He says, because, look, if, as we can see from U.S. history, it was the states that created the federal government in the first place, and they are the principals, therefore, to the compact, then ultimately, in the last resort, these principals, these creators themselves, have to have some last resort way to intervene to stop the structure from being destroyed by lack of fidelity to its founding document. So the principles, the states themselves, cannot, in the very nature of things, simply be helpless spectators as their very own creation destroys itself and disobeys its own document. There has to be some recourse. So ultimately, there is finally, according to Jefferson and Madison, some recourse the states must have. And for Jefferson's point of view, there was a final arbiter, and the states interposing to prevent the enforcement of unconstitutional laws was the beginning step toward reaching that final arbiter. And that final arbiter is the people themselves, the peoples of the states themselves assembled in convention. And that if there was some dispute between the states and the federal government over constitutionality, well, then the people should, in convention, assign the disputed power expressly so that there is no doubt, so that it is not dubious any longer, assign it either to the states or to the federal government and settle it once and for all. So it's they themselves who should make these decisions, not a group of judges who, are beyond the control of the people. That's very much an elitist, capital F, Federalist, Alexander Hamilton type of view. Jefferson and Madison had rather more confidence in the good judgment of the people.
Now, is this are you referring to like a vote of the people of a certain state, or a vote of
what I'm
everybody,
imagining here is that in the depending on how I interpret your question, you could mean. Do you mean how is nullification carried out, or how is this final resort?
How would you decide, how the state would get their way, so to speak?
Right. Okay. Well, it seems like there are different ways of going about it. I mean, you could go about it in a very, very solemn, super formal way, whereby the state convenes a special convention analogous to the state ratifying conventions. I mean, that's been done. But it could also be, because it's also been done, a statement of a legislature or a governor. I mean, the governor is the one who's given the task of enforcing the laws. Well, we had a Connecticut governor, Jonathan Trumbull, in the early 19th century that ordered state employees not to cooperate with or give effect to some of the unconstitutional searches and seizures that he thought were going on in pursuance of Jefferson's embargo. So it could be done that way. It was done by the state Supreme Court in Wisconsin when the state Supreme Court declared the Fugitive Slave Act of 1850 to be unconstitutional. Now, later the U.S. Supreme Court came in and said to Wisconsin, you're not allowed to do that. This is a perfectly constitutional law. You're not allowed to dispute it. So today, I mean, that puts people in kind of an uncomfortable spot who are going to, challenge the intentions of those of us who favor this Jeffersonian remedy, because basically their arguments trace back to the Supreme Court and its upholding of the Fugitive Slave Act. I mean, I'm not sure that's the side I'd want to be on.
Right, and for folks that might just be tuning in, the whole idea of nullification and declaring federal laws null and void by the states, and you were sort of getting into this, but I was wondering if you could comment on people such as, say, like Georgetown law professor Randy Barnett, who, would argue that nullification itself, that the states itself is unconstitutional.
Yeah, I've answered this. I'll do it now, of course, too. But on my website, TomWoods.com, I've got one of my recent blog posts links to my big article that I just did, where I, sort of did a point-by-point, frequently asked questions sort of thing. But yeah, isn't this unconstitutional? Well, the answer to this is sort of to go back to what the state ratifying convention said, because Madison says if you want to know what the Constitution means, then you consult the state ratifying conventions, because that's where you find out what were people being told that they were getting themselves into. Well, they found that out at the state ratifying conventions. And Jefferson said, if you want to know what the Constitution means, you listen to what its friends said about it. Well, when we look at the ratifying convention in Richmond, Virginia in 1788, here's Virginia, the most populous state. Most influential statesmen are coming from Virginia, very, very significant. And at their ratifying convention, the Friends of the Constitution assured skeptics that this would be a strictly limited federal government, and that indeed if the federal government tried to exercise any powers that were not delegated to it in this instrument expressly, then in that case, skeptics of the Constitution were told Virginia would be, and this is the word they used, exonerated from the exercise of that power. Virginia could simply say, well, look, we never signed on for this power. We signed on only for the ones that are expressly spelled out in the document. So we can see that this isn't something that Jefferson, just made up because he got drunk one day. Jefferson knew what had been promised to people specifically by the people who were drafting Virginia's ratification instrument, told them that they would reserve to themselves this power. So that, I think, is a pretty clear indication. And the mere fact that the Constitution doesn't mention nullification is by no means the end of the argument, because that's not how the Constitution is structured. It doesn't list any of the powers of the states. It lists only the powers of the federal government and restrictions on the states. The federal government is assumed to be restricted from doing anything not listed, and the state governments and the people are assumed to have powers that are not listed. That's how the Constitution is written.
Right, I believe you're exactly correct. And I know you don't have a whole lot of time today. I was wondering if you could ask one more question and just kind of wrap things up. And,
sure.
And one of the things that we talk about, and I think your book, your separate book, Meltdown, really gets into quite a bit on the show, is the idea of state bailouts in states like California and Illinois being in very dire financial straits, and across the lake, so to speak, in the EU, we saw Ireland print up 51 billion euros, which is about one-third of the figure that they use for annual GDP. So I was wondering, do you think that the states will proceed with nullifying the federal government, or really the Federal Reserve's monopoly over legal tender laws, in the event that we really do have a meltdown with the dollar, with it plunging in value and that sort of thing?
Well, what I sort of think might well happen is that we'll be in a situation in which the federal government, in tandem with the Fed, will do quite a bit of damage to the dollar. This is not some crazy radical right-wing theory. I think pretty much we all know that something pretty terrible is going to hit us sometime in the coming generation, maybe even the next 10 years. So what I think is likely is that the federal government will be in less of a position to be able to bully the states anymore, because it's going to be in such financial straits that it'll be much harder for it to use the carrot and the stick with the states.
Isn't that the main weapon the federal government has is the fact that they collect income taxes at the federal level and then dole it back out, and if the states don't behave, they don't give it to them. Right.
Although I wonder if that's necessarily decisive. If a whole bunch of states simply said, now look, this particular, if a whole bunch of states said, we're not going to carry out this provision of the Patriot Act because it's a gross violation of the rights of the people, and let's say 24 states did that, it seems unlikely they'd be able to get away with depriving 24 states of money that they were expecting. But still, it does put them in a tighter spot. But I think the more difficulty the federal government gets into, the more de facto nullification will take place. And certainly the more the state governors will say, look, everybody's suffering in the country right now, and what I as governor have to do is go through my state budget and look and see where can I save the people some money. And what he may well do is say, look, we can't afford all these mandates the federal government imposes on us without giving us the money, so just to keep our heads above water, we simply have to stop doing some of these things, and then you'll have a kind of a de facto nullification.
Great, and Dr. Woods, I can't thank you enough for joining us on the show to talk about your book Nullification and everything. I really, really, really appreciate your time, and thanks a lot for enlightening us on this whole subject.
I'm very glad to do it, and as I say, there are a lot of resources on this at TomWoods.com. There's no way you can send me any money at that site, so I'm not trolling for money. Either you try as you may, you will not find my address or a PayPal or anything. But anyway, thank you guys. The pleasure was mine.
Hey, thank you so much.
We'll have you back again sometime, and we'll be back after these messages. This is Freedom News Hour, Surviving Meltdown, the Progressive Radio Network.